Right now, the state is giving its rebuttal argument. Let's get back into court.
Members of the jury, we're almost there. Mr. McClymont told you that this gang war in Jacksonville is tragic. That's the only thing that I think that the state is in agreement with what he just argued to you. It is very tragic, the killing on both sides that happened, and the law places a high regard for the sanctity and the protection of human life. And the law protects everyone equally. It doesn't matter who the victim is, and it doesn't matter what the victim does for a living. If you purposely intend to commit first-degree premeditated murder and kill a person, regardless who that person is, and we have proven all of those elements, the law requires that that person be convicted. And when you talk about the standard of proof beyond a reasonable doubt, that is what you have in this case, and you have higher than that. The defense attorney has asked or suggested to you, where is the DNA? Where is the fingerprints? All of that type of evidence is to establish one thing: who is the perpetrator? When there is a killer and there is no evidence, there is no eyewitness, and there is no videotape, then the law allows us to present evidence, direct evidence, and circumstantial evidence to you to establish and prove the identity of the perpetrator. Somebody broke into a house and shot and killed a person, and nobody saw it, and that person broke a window to get in and left their blood on that window. That could be used to establish what? The identity of the perpetrator. If they weren't wearing gloves and they touched that window and the law enforcement officers dusted for prints, they would send it off. It is very, very rare when you capture the entire crime on video. This age of digital technology proves beyond all reasonable doubt what happened in this case. You don't need an eyewitness to come in here and tell you what happened to Charles Jones on June 23rd of 2024. You don't need a fingerprint analyst to come in here and tell you who killed Charles Jones on that date. And you certainly don't need a DNA analyst because you saw it. His murder is captured on video. There are 2 cars involved, and you saw what happened at each and every location. We don't have to present DNA evidence to you. We don't have to present fingerprint evidence to you. Law enforcement officers didn't need to submit any sort of DNA to the labs to figure out what happened in this case. Because of digital evidence and video evidence, you know everything that happened to that victim. He was hunted. He was stalked. He was hunted at teasers. He was stalked, and then he went to a second location to Truth 18, and he was followed, and he was hunted, and he was stalked. And you saw both of the vehicles that are involved in this case. And she is in the silver Chevy Cruze. There is no doubt about that. We don't have to fingerprint the silver Chevy Cruze. We don't have to dust it or swab it for DNA to know that she is in that car with her boyfriend. You saw that silver Chevy Cruze. You saw it at teasers, following, going, parking, and then the 2 of them get out to get in eyesight of the victim. All of that is clear. What is also clear is she is not going up to the club. She's not going clubbing. Neither is her boyfriend. It is for one purpose: to stalk the victim, Charles Jones, in this case. And at the second scene, All of that is on video as well. You see the parking lot of that location. You see it with your own eyes. And there is no doubt who every single individual is in both of those cars. We have proven it beyond and to the exclusion of all reasonable doubt. And you saw it at the Home to Suites video. You saw it at the USF poll cam. That victim is followed. And you saw those text messages from Sean Gathright to Kayla Enright. They want to know where Julio Foolio is, where 6 is. And in those messages to Kayla Enright, you know that they are watching him. You know, and you saw what Charles Jones is doing that night. He's on Instagram. When Sean Gathright contacts Kayla Enright, they say what? We're looking for 6. He's in Tampa. He's at an Airbnb. You saw his Instagram story. He's posting live. He's at an Airbnb. The only location that they weren't aware of that wasn't planned is this pool party at the Airbnb. Defense has suggested to you, Kayla Enright, she's not charged. No, she's not. There is a law, the law of principle, that shows that we have to prove that the person who assists, the person who is a principal, intended the crime to be committed and did something to assist. Kayla Enright is in no way in the same position as this defendant. She is not in a vehicle with all of the perpetrators. She is not stalking the victim. She is not in Tampa. There isn't any evidence other than a message to her while she's in another location to contact someone to find 6.
All right, so we're just a little bit behind. Right now, live in that courtroom, the judge is giving the last little bit of jury instructions, and then this jury will have the case. Let's bring back in criminal defense attorney, former prosecutor Marie Peretta. Marie Peretta, we saw sections of their closing arguments. This was one of those cases that going into the closing argument, I was still sort of on the fence, and I gotta say, after listening to both, I thought prosecutors really sort of brought it home, especially the idea that what she was wearing in the car, the fact that she was in the car, she did have the mask on as well. Hard for me to believe that she didn't actually know. And actually, if you just noticed, the deliberation clock just came up, literally just getting started. It's hard for me to believe that she didn't know what was going on. Where do you stand after listening to some of those closing arguments?
I think she knew what was going on, and I think the prosecutor is still going with that WAP theory. She's a WAP. She has a willingness, active participation, but it's not that clear. All of it we know happened, the stalking, the premeditation, all of that, but I don't see her as the principal. I still see the jurors could look at her like, you know what, I have a daughter. If they have daughters, they get caught up with the wrong guy, and her mere proximity and presence doesn't equal foreknowledge, participation, and first-degree murder. That's a big, big charge. Maybe if they charge her with something less, but to say first degree, you knew about it, you actively participated, I don't think they're there. And I think, again, it could go either way, because I just see the confirmation bias argument. By the way, the defense team is really very impressive. That young attorney, Jeremy, wow. His delivery, the storytelling, he has it going on. And he creates a little bit of a reasonable doubt as far as the conspiracy. She could get away with this because I don't see the connection.
Yeah,
I don't see it.
The fear is that it's really just guilt by association. But as our friend Franz Borghardt always says, play stupid games, get stupid prizes. You know, you start hanging out with these people. This is where you find yourself, right? But here's the deal with the principle, and I agree. It seems like a stretch because it's so serious. It's first-degree murder. That's going away for the rest of her life. Conspiracy gives her maybe some chance to get out. But all she has to prove for that is that she helped to commit the crime. And when we talk about the fact maybe she was just there, but also she was part of this lookout team and was providing information about location of the victim, that kind of fits the bill, doesn't it?
No, because it doesn't mean she knew what they were about to do. Proximity and presence, and even him using her phone is not enough, because we've already established he had control over her and there was some fear there. Even though the judge didn't allow them to duress defense, she brought it out there. There's enough. That was my man. There was some domestic violence involved. He took my phone and all those texts came from my phone, but I didn't have nothing to do with it. I'm so scared of him. He's still in prison and I'm talking to him against my lawyer's advice because he got people on the outside that could hurt me. All of that, it helps her. This could go either way, Michael. It's not a slam dunk for anyone here.
Yeah, I would agree. But then again, that assumes that they believed her testimony. And I can tell you just from a quick survey online, a lot of people didn't believe her testimony. But if they did, I agree 100%. She certainly has a shot. And maybe one or two, you get a hung jury here. We just don't know. Marie Panetta, thank you so much for being with me on this Friday. Truly appreciate it. Folks, stick around. Coming up next, we're going to review the 3 things that we've learned today in the cases that we've been covering from coast to coast right here on Court TV. Welcome back. Here are 3 things that we've learned on this Friday. First, in Florida, jury deliberations are now underway in the Julio Foolio murder trial. The defendant, Alicia Andrews, testified today before closing arguments got underway. Prosecutors say she traveled with her boyfriend to Tampa and helped track down the rapper, whose real name was Charles Jones, before he was shot and killed in an ambush attack. Andrews faces life in prison if convicted of first-degree murder and conspiracy to commit murder charges. She's the first of 5 co-defendants to stand trial for the shooting death of Jones.